Welcome everyone to this second session of Hands-on Law and Tech webinar series hosted by Olya Kanevskaya and myself, Przemysław Pałka, the co-editors of the research handbook on law and technology published last December by Edward Elga. The idea behind the handbook was to offer a meta-reflection on the state of various fields, various discussions, making up the law and technology space of scholarly reflection. And now that the book is out, we also have an opportunity to match the authors' names to their faces. And we also thought about organizing this speaker series.
Right, so the idea was indeed to match the faces to the names of the authors, but also to give them a platform to discuss further the things that they maybe wanted to include in the chapters, but didn't. Things that are happening, law and technology, and especially technology is in development. There are a lot of things that has been on the policy agenda in the literature as of December 2023. So we kind of wanted to bring the authors together once again in smaller groups and discuss relevant issues. And today's relevant issue that we're discussing is the regulation of the AI. So I think that's one of the, if not the most relevant topic now when you talk about technology. We have the AI Act approved. We have a lot of bunches of legislation in the US and the EU that are about technology, and they also touch upon the AI. So there is a lot to talk about. And we have today three excellent speakers who obviously contributed to the research handbook, but obviously also have a lot more to say. So the first speaker is Professor Burkhard Schafer. He is from the University of Edinburgh. And then we have Professor Laskowska-Litak from the Jagiellonian University, who is associate professor, as I just understood, from the Jagiellonian University in Krakow, and we have Hanne Hirvonen, who is a legal counsel, but also finishing her PhD, I guess, on something that has to do with AI in the University of Helsinki. So welcome, great that you're here. Also, thanks a lot for the speakers for being here. We will have the three interventions, and we will also have the time in the meanwhile to ask the questions and also for the speakers to interact among themselves. If you have a question, please drop it in the chat box or in the Q&A. We will collect them and we will discuss them or answer them. Now, without further ado, I suggest Professor Schafer can start.
Yeah, of course. Thank you. And thanks for the invitation. Yeah, something very, very quick, I would say. When Palka initially invited me to contribute to the book, he promised me it will be very easy. Just do something that you've always been doing. Won't take any time whatsoever. Write something about formalization. I thought, yeah, I teach that. I've been working in that field for 25 years. That should be easy. I can very, very quickly do this. And the original idea was simply, what happens if we take legal text, in particular legal rules, and we formalize them in such a way that they become computational? And that obviously can be used then either for more traditional legal support, legal expert system, uses in the justice system, but also increasingly as a form of compliance by design. If you want to drive on our roads, you have to pass a driving test. As part of this test, you have to pass a theory test where you are interrogated about the applicable laws. If we as humans have to do this, then maybe an autonomous vehicle should also be able to do this. So the idea is really to translate road traffic law, put it or formalize it and put it on a machine. And I wanted to write a little bit about that, some of the difficulties we've encountered in that space, some of the shortcomings. And when I tried to come up with a good framing for that, I initially just wanted to put one extended footnote on the similarity between formalizing a legal rule so that a computer can understand it and translating a legal rule so that a human from a different country, comparative lawyer or conflict of law lawyer can understand them. And I try to make more or less a throwaway comment on the similarity between the process of formalization and the process of translation, and that both of them require a core legal skill, that is legal interpretation. You can't formalize or translate legal text correctly if you are not at least to a certain extent, familiar with the method of legal interpretation. So that was, broadly speaking, the idea. And that got me to page 1 of the paper. And then there was this darned footnote. And that threw me down a rabbit hole on translation and machine translation, and lots fascinating ideas on the ethics of translation and machine translation. And it changed the paper already quite considerably from what I had originally in mind, but in particular gave me really a new research project on the role of machine translation in the legal justice system. The ability of an asylum seeker to think and read and talk in their own language, for instance, relying on machine translation for the process. The task of a lawyer with a conflict of law case to get reliable access to foreign literature. And I realized increasingly that this issue of machine translation or automated translation of legal text has been largely ignored by the legal tech community. There are hardly any papers on this. So I got really interested, fell down massive rabbit holes, one after the other, and then also encountered, obviously, as we've just heard, the AI Act, the EU AI Act. And I tried to get these two together because I'm increasingly convinced that machine translation might be more transformative for the justice system than many other technologies that we find, more than predicting the outcome of human rights cases, which is a perfectly silly application of AI as far as I'm concerned, more than expert systems, which didn't work in the 18th and they don't work particularly well right now. But there I think that we are making a real potential contribution to access to justice and a fairer system. But they are really difficult to classify under the Act. It is really difficult to know where they belong. They are foundational model. If they are used in the justice system, they might be high risk, but as a translation tool, well, you can also use them to translate a menu in a restaurant when you're on holiday. So it's very difficult to get a good handle on it under the AI Act, how we should deal with translation tools. They do not seem to fit into that overall landscape. And that is one of the things that interests me at the moment. What are the ethics, the constraints that we should use as lawyers when we are relying on these tools? With AI for People, we drafted ethics guidelines for the use of legal tech and started to look also into this issue. And then two things really, again, sidetracked me just a little bit, and I hopefully they will link to both Hanna's and Eva's contributions later on. With translation, for instance, it was always at least contested if the translation can attract its own copyright. And there's a long discussion about the IP implications of translation. And then there's obviously now also an emerging discussion on the IP implications of computer-generated works. So bring these two together and you get a really thorny question, that is the IP status of automated translation and how we should think about them. And again, I think the AI Act, which was not originally intended to deal with copyright issues, more or less inadvertently drifted into this territory and now has at least some provisions that also deal with the intersection of IP and AI. Every time you use a browser extension that translates a website, you're also training an AI. What is going on here? What should we do about that? How should we think about this? If you go to a website with UK court decisions and you translate it, again, just in your browser extension, that's a problem. Well, in the UK, we have that irritating habit to identify cases by the names of the parties. And we also put in the names of the witnesses and the judges and the counsel. Lots and lots of special category data under the GDPR. And now when you translate it, I would say you are processing it all over again. So I think suddenly there are multiple strands of discussion that we have to have. And for me, and in that respect, I also emotionally, philosophically align very much with Hanna's papers and her collaborators. As exciting and as novel as all of these things are, it is sometimes good to step back and say, well, is this really that novel? Did we have these discussions maybe before? And I think we do. So that was for me then the other rabbit hole I was falling into, tracing back the history of machine translation and the ethical debate surrounding it. And I don't know when you think the first machine translation tool was built. Any numbers you want to throw at me? Any year?
Well, it was either the Sumerians or Leibniz.
Oh, excellent. You are my sort of person. You are not going to be fooled by me. Yeah, you're almost right. It warrants the Sumerian. That's a little bit too early. At least I don't know of any Sumerian text on machine translation. Leibniz is too late. There was a 12th century machine developed by missionaries, which essentially were simply concentric circles where you have vocabulary in different languages. And then if you moved it around, you could see how key terms from the Bible had to be translated into other languages. And even then there was a discussion, is that an appropriate treatment of holy texts? So for me, as novel as a lot of this discussion is, and as cutting is, and as important for the justice system, it's remarkable how long sometimes the trajectories of these discussions are. So yes, for me at the moment, a really interesting research project directly triggered by that chapter. How do we deal with automated translation of legal texts in the justice system? What does this mean for us, access to justice? How should we regulate them? And that has both the IP dimension and also the sort of long history dimension to it. So that's me.
Thank you very much, Burkhard, for this intervention. Indeed, there is this interesting connect and disconnect between the AI and law community and the AI Act, right? Like on the one hand, people who've been doing this for decades obviously are interested in the Act, that they have the technical expertise and everything, while on the other, the Act itself does not seem to be drawing too much from that research, right? Like the division of high-risk systems and non-high-risk systems by the area in which it is used clearly misses the fact that there can be systems that can be used in law enforcement 0.6 or judicial application 0.8 and many other contexts, right? So when does it become a high-risk system? Will clearly be.
And I totally agree. And one thing that we definitely see, the sort of philosophy, the mindset of the drafters of the Act, when they thought about legal tech or AI in the justice system, they thought about the sort of systems we built in the late 1990s, early 2000s. They are decision systems. There's this focus on decision, and that is the least important, least used, least problematic in many ways use of AI in the justice system. And there are totally harmless uses of technology and the AI in the justice system that don't merit the high risk label at all. And there are other high risk applications that probably fall off the radar because they don't have this decision quality to it that the AI Act so much focuses on.
Great, thank you very much. So moving from legal tech to what was already flagged, copyright. You know, everyone I'm sure at some point got excited about, you know, can AI systems be authors under copyright or not? Unfortunately, we have an expert with us on copyright, and if you could, Eva, give us an overview of sort of what are the things being discussed in your communities of discourse right now? Which do you think are important? Which are overhyped? What's your take on that?
Thank you, Przemek, very much. And let me firstly express my deepest gratitude that I'm here with you. It's such great work for you and kudos to you organizers. I will just pick up from the place where Professor Burkhard Schafer led our discussion. Well, with regard to the copyright law, so generally I'm specialized within intellectual property law, mostly within the copyright law. And when I start to discuss to people not specialized within intellectual property law, what are current trends and what is with the AI and the IP protection, I always start with a statement that whenever we think about IP protection, we have to bear in mind that we're speaking about legal institutions invented in 19th century, and we have to make them fit to the digital environment, which is obviously quite difficult, if you can imagine. Firstly, because different interests were in place and different interests were discussed, and not every interest and not every interested party was balanced in a way that their perspectives and interests and rights and freedoms were included within the legal institutions. And that was exactly the case and is exactly the case of the copyright law, mainly because firstly it was invented in order to protect the weakest party, the authors, the creators, which was initially invented as a human and not artificial intelligence or AI-based software, or even owner of the AI-based software, which obviously leads us to a question posed by the emergence of AI technology, that whether we may be able to address the AI within the copyright protection or IP protection in general, or should we even do so? Mostly because the question is the problem is multifaceted, and that's the current trend, to answer your question, Przemek. A current trend discussed within the IP debate. Shall we even address the IP? Shall we even address the AI-based solutions within the IP protection? Because whenever we think about the AI-based software, we also obviously have to think about companies and corporate entities that lead the AI technology businesses and developments, and they are obviously certainly not the weakest party that shall be protected. On the other hand, there is obviously an argument or statement that copyright law, or generally the IP protection, is supposed to be some sort of incentive for all the people, companies or entities to develop new technologies, science, knowledge, etc. On the other hand, such an empirical data is not verifiable or falsifiable. Therefore, the question remains what kind of legislative policy is going to be made in future. Nevertheless, on the other hand, there are many arguments and debates around the question of access to knowledge and access to culture with regards to AI-based and data mining policies, data mining technologies. And that was what was mentioned already, that at least whenever we do any kind of translation or whenever we make our consumer choices, some sort of AI-based software is already learning on the data we left somewhere over the internet. And the question is, and that's quite interesting question, what are the costs of that data, and who shall be responsible for that cost, and who may be able to use them in order to exploit or develop or train the AI systems in future. So there are worthy debates now and currently trending within the IP protection, within the IP law, most of them associated around the question of what shall be protected, especially with regard to the generative AI systems. The second one is the question of the liability. And obviously, whenever we think about the AI, generative AI that uses someone else's work and generates a new work, that's the question who shall be responsible for it. And obviously, also the question of the data that is left somewhere over the internet. The last is quite interesting also because generally the IP protection, generally the IP law shall not contain or shall not grant any sort of exclusivity over the data, sort of, the bare idea. Nevertheless, the data in a massive data is quite effective in a way that not ineffective. It's quite an economic advantage for people or companies or entities that collect the data and use them in order to train and exploit then later AI-based software. So that's the kind of debates. I suppose none of them is already solvable. Nevertheless, quite interesting from the perspective of legislative policy. And I think, at least from the perspective of how the copyright law evolved from quite technical, even regulation to economic regulation. The question might be for the future how it may resolve, what's the regulation in future may look like. Yeah, so briefly stating.
Thank you very much. Thank you very much, Eva. Indeed, fascinating debates, not least because, at least from my complete layman perspective, it seems that the development of new protected sticks in the copyright bundle used to favor the copyright holders in the past, right? Like every now and then we add one so that when we're broadcasting, when we're making available to the public, the publishers will be protected. Whereas now there is this big clash between, on the one hand, corporations holding the rights, and on the other, corporations building the AI systems. The lawsuit between New York Times and OpenAI has just two giants fighting, and the question is which one will prevail. But yes, thank you for that. And so from copyright, we'll get to straight on AI regulation. And Hanne, if you could tell us your perspective on what are the things discussed right now, which you think are important, which not, and generally your thoughts. Thank you.
Sure, thank you. So yeah, first of all, I come from the University of Helsinki Legal Tech Lab, and I wrote with my colleagues Riikka Koulu, Suvi Sankari, and Tatjana Heikkinen the chapter to the book. But now I'm here by myself, but just wanted to mention them too as the co-writers. And all of us, yeah, we have been following the preparation of AI Act from the very beginning, and we have been very interested in the AI regulation. And what we actually studied in our article or the book chapter, and the discussion we have been following also more broadly, is how to define AI in this context. Because obviously when you decide to regulate some technology, you have to be able to communicate which is the scope of the regulation. So you need to define the AI. And it was tricky. And now it will be interesting to see, now that we have the AI Act, how well the definition actually works out. So that's probably something we are now, and I'm now interested in. How did the definition of AI turn out, and what sort of effects it will have, what is within the scope of AI Act and what's out of the scope. Yeah, and we were also looking back to the history, because it's interesting how we have this sense of urge that there is AI coming now, and it involves so many risks, and we need to react, and we need to like protect citizens, and that sort of discussion, which is many times true, but if you haven't been following the discussion for a longer time, everything might seem really new, and thus it was interesting for us to look a bit further back and see how another type of technologies have been also raising conversation, and then when people become more familiar with those technologies, they are not called, for example, as AI anymore, and then the focus moves forward. It's natural, but also it raises up the question, for example, in 5 or 10 years, how does the definition of AI in the AI Act or otherwise lasts, and do we call something totally different as AI in the future?
Great, thank you very much. There is one question from the audience, or rather a comment from Arno Loder, another contributor to the handbook, and I'll read it because it connects nicely to both to the question of definition and to what Burkhard was saying. Since decision systems never were regulated, harmless as you say, I guess the name AI Act is wrong and should be more seen as deep learning or something like that act. That is indeed a fair point, right? People who've been developing the systems for a couple of decades will see how it is mostly machine learning / deep learning that is indeed in the regulatory frame, while on the other hand, the way the definition is phrased seems to be much broader, right? We're not necessarily regulating the problems posed by the systems at which we hint with the definition we use. You're muted, Burkhard.
Yeah, and absolutely, and there's for me a slightly weird disconnect in the act in that respect. Now, just to be totally clear, and that is a hill I'm happily going to die on with my army of killer robots. Good old-fashioned AI is AI. And I would definitely fight for that. Also because some of the more recent developments, like neurosymbolic systems, try to bring these two back together again using symbolic reasoning as guardrails, for instance, on machine learning. The definition in the AI Act is very wide. So symbolic systems definitely covered. All the measures that you are supposed to take seem, however, to be geared towards machine learning, like debiasing your data and XAI and all that. So there's a disconnect between the wide definition of AI and the substance of the rules that seem to be much more appropriate to data-driven approaches. And that could then easily mean overreach for concrete applications where people try to do what is required, even though it doesn't really fit to what they are doing.
It almost begs the question, to what extent these definitional battles were really about the scope of application of the act, right? Which is what they should have been. And to what extent they were just trying to solve the query that every single paper written between 2017 and 2022 on regulation of AI starts with, which is there's no commonly accepted definition of AI, right? Like just trying to get the definitional space right. Yeah, Eva?
Yeah, sorry. So I wanted just to add something at the bottom. So I wanted to research the question what's the best definition of AI would look like within the context of AI Act, and then I discovered that within the computer science that is mostly, that mostly focuses on artificial intelligence, there are so many definitions of it: the capability approach, the functionality approach, the generative AI, which is supposed to be different than general AI sort of thing, utopian classic approach. So because they are quite divided within approaches and different reasons how and what shall be called within what shall be called as an artificial intelligence, I think it might be quite challenging to define it within the legal regulation, at least at some point, especially with regards to different legal branches like IP law or consumer protection or data law in general. So probably that's probably the source of all the problems, I think.
My preferred definition of AI still is a technology that can perform reasoning that, if a human would do them, count as intelligent and, very important, and current systems can't do yet. AI is always the future. We never have AI. AI is always something that is just around the corner. So and I think that is part of the problem with regulating it. I think the concerns are not AI. The concerns, and again, that goes back also to Hanne's and her paper and her group, the concern are automation. There's a much longer history again about that process. And if you can take parliamentary debate from the 1830s and black out steam engine and give it to your students, and they will say, oh yeah, that's about AI, it's about black box, the many hands problem, we don't know why they suddenly explode, we don't want to hamper innovation. So I don't think AI is really what we are worried about. We are worried about our place in the world. What is the role for us as humans? And again, for you, I think on the IP side, that is why it gets so heated so quickly, because that is the genuinely human activity, being creative, making works of art where we feel maybe the most threatened. But it is not AI that is the problem. It is this sort of feeling we are losing control over something that we ought to be in control of.
I think it's also something very... Oh, 3 people talking at the same time. This is getting interesting. I think it's also something very the thing lawyers do, right? We really stick to the definition. We want to define things. We want to know what it is we apply the law for, and like as precisely as possible. But I think Hanne had wanted to say something, and we also have some list of questions.
Yeah, I just wanted to continue from what others have said and what I said also before. I think the discussion has focused quite a lot on the risks and harms that the outputs of certain AI system may cause, and we haven't been talking. At least I have some. Anyways, the focus hasn't been that much on the inputs and legal questions that relates the input data, but there is connection to the IP rights, and there is connection to data privacy, and it kind of like connects if we don't look the how to regulate questions, but we look the ongoing litigations and cases. They are mostly now touching either the copyrights or the GDPR supervising cases where there is a generative AI model and what has happened with the output data, the input data and the rights concerning the input data.
Great, thank you. There is one question that directly addressed at Hanne about your opinion on where do you think translation systems that Burkhard were talking about would fit within the AI definition, and how that would affect academic research producing this kind of systems.
Well, that's a difficult question. Obviously, if we would look one single translation system, we would have to understand how does it work, and then compare it to the definition of AI and see if it fits to the scope or not. And then if it is in the scope, then look at the risk-based model, the hierarchy, and see if it's risk, if it's one of those high-risk systems. But as Burkhard described, it's not very easy. It sounds easier than it is, because then if is it meant for some specific use case, then you can compare that use case to the risk model. But if it can be used in very different situations, how you then fit the case to the risk-based model. Honestly, I haven't been thinking about this further, so I don't know if Burkhard can add something.
Yeah, I mean, the good thing is foundational AI, the general models, they are now in the final version that was, after all, contested a long time, but it still feels a little bit as an add-on. Last-minute negotiations, intense last-minute negotiations. The outcome is better than I feared it would be, but still, it's not always totally clear to see how that fits to the rest of the act and the risk-based approach. But it simply also illustrates some of these difficulties. And when we were recently on holiday on Corfu, I thought I'm fine. I had Greek at school 35 years ago, classical Greek, that is. And I quickly realized that my ability to ask how many enemies you have slain with your bronze sword was not really helping me negotiate my way through modern-day Corfu. And my wife simply took her translation tool, and that worked extremely well. We translated menus in restaurants. We translated legal text to find out if we had to register with the tourist for tourist tax, and we translated when I got headache, making sure that I got paracetamol in the right doses. Which of these applications, all on the same mobile phone, would you say was the most risky one?
The paracetamol, probably.
That's what most people say, strangely enough. Yes, but the thing is, and again, their context comes in. I knew simply from the Latin word what the active ingredients were. I could make a lot of sanity check to make sure. Look, the question really was, is this 200 milligrams or 400 milligrams? I just need to find out where in the sentence that is. So I think for the concrete application, that was relatively harmless. I would say the most risky one was translating a menu in a restaurant. If I overlooked an ingredient to which I'm allergic there, that could kill. And you do not, especially when cultures make up names for dishes, which can be rather arbitrary. If you go to Austria and you order bat, Fledermaus in a restaurant, you get a cut of beef. These things are not logical. There, the risk of mistakes is very high. The risk of danger is really high. The AI Act probably would say the legal one is the most dangerous one. That is, after all, administration of justice. The medical one, possibly because medical device regulation, menus, who cares? So I think these things show the difficulty of identifying the right context for the right purpose of regulation.
Is it time to get into our second question round, as we're already sort of bashing the AI Act, and then maybe let's do it. Let's do it explicitly.
Why not to continue? Exactly. Let's do it explicitly. We get some really nice, by the way, comments and questions in the chat reminding us that they're regarding the general purpose AI models, that they're also already introduced in 2022, but the enforcement and the penalties changed with the final version of the Act. So thank you for this comment as well. All right. So there's also a question in the chat about why must AI always be something of the future? And I kind of want to pick up on this and invite our speakers on a little time travel journey in 2 or maybe 5 years from now on. How do you think the regulatory landscape of AI is going to look like? Are we all going to be like they're going to be the EU AI Act, which is obviously imminent now? They're going to be the US regulation, China regulation? Are they going to be completely diverse? Are they going to be merging? Are we not going to be regulating AI at all? Well, Burkhard, perhaps you can start again, and then we just move in the same order.
Okay, that's a really tough one. I mean, I was obviously slightly facetious when I gave that definition of AI is always in the future, but it is based on historical experience. The moment we understand an AI too much, when the mystery is gone, when we understand the contours of the technology and look under the hood, the reaction historically always was, "Oh yeah, that's the only thing that it does." How disappointing. I thought this was really, really amazing. And now we understand it. It's like when you have a stage magician and suddenly they explain the trick and you feel, it wasn't magic after all. It was just a trick. And I think we do see the same thing with AI through the centuries. Once we understand it, it blends into the background. It just becomes software, as I think Arno said. It's just another piece of software that creates these contours. As far as regulation is concerned, I give you two visions, totally different ones. The first one is bloody generative AI is going to write more and more papers automatically, which reduces the marginal costs of producing policy document, minutes, papers, and so on and so forth, which will result in a huge explosion, not just as it was with email, a huge explosion of longer and longer papers getting written that no human can read any longer. But generative AI is also good at reading and summarizing these papers. So we will face a world, especially in large administrations, more and more papers are generated by machines that are then only read by machines, and that keep them off the street and out of harm's way. That is definitely one possibility. I'm worried that the marginal costs of document production in terms of effort and time are falling so much. That can't be a good thing. I think the most exciting thing for me in terms of regulation, and exciting, I mean in the Chinese way, we are living in exciting times, and I'm not sure it's a good thing or a bad thing. My views change on that. Is the question, do we need a totally different mode of regulation? And I don't think with that, the usual discussion, self-regulation, standards, whatever, but that AIs or part automated system become addressees of norms, and that we therefore do not just enact laws any longer in natural language, but that we get authorized forms directly as part of the legislative process that give the official version of the code representation of a piece of legislation, the sort of code as law movement. That's at the moment played around with. A couple of countries experiment with it. It addresses a concern that people like Mireille Hildebrand have voiced, that who also obviously contributed to our book, that we leave too much to software developers, legal decisions, interpretation decisions to software developers, regaining control to parliament, but totally changing the understanding what we think an act is, and moving to a world where we have a version of the act for human readers and a authoritative official version for the machine as reader. That would be for me the most exciting, problematic, potential future development in our space.
That's very intriguing. And I was also thinking, kind of linking back to the discussion about the definition of AI, definition of risk. I mean, it's not the first time, at least in the EU and also in the US, it's not the first time when we have like this fluid definition sort of. We also had the dual use legislation, right? When the goods can be used, a microchip in the computer can be used to use a laptop, it can be also used to create a bomb. So we do have some kind of an experience with it. So what actually have we learned from there? To what extent we can implement it in the AI Act, not trying to compare AI and export controls here, but for the purpose of the argument, for the sake of the argument. So it's a very intriguing point. Eva, do you have some more positive view on the future of AI regulation?
You're quite optimistic. Positive. All right. So I would just I would like to stay positive, but I presume there might be two. So I have two predictions. Both of them are quite pessimistic, nevertheless, with some advantages, hopefully. The first one is, so to say there are not opposites, but probably at least one or half of one of them may be possible. The first one is that there is going to be no actually general or even issue-focused AI regulation, with one exception of the AI Act that is already happening, and nothing will actually happen. So that's exactly how it was with regard to previous technological breakthrough changes, that there was some sort of a little step towards harmonizing or regulating some sort of technology within the IP law or outside the IP law. But outside of this little step, there was nothing at all. And we were mostly convinced to apply general rules, and these general rules may be applicable in future. So I don't think it is quite optimistic. I think it is quite pessimistic, because if there is no regulation, and obviously there won't be, and with any with all the predictions with regard to responsibility, liability, the harmful speed, deepfakes, etc., and so forth, it might be quite disturbing for the society as whole, and as particular groups. So that might be one prediction. And the second one, hopefully it won't happen, but the second one is more associated with how the IP law was evolved within the European Union. Initially, there was some issues, there was some doubts with regard to whether the IP law shall be harmonized within the European Union, and with very small steps, a specific focus or particular problems focused, some sort of harmonization followed. So initially we had directives on satellites, cables, software, etc., and so forth, but not general regulation with regards to copyright law as such. Maybe the same will happen with regards to AI, but not as an AI in general, but with regards to specific problems or so to say, AI exploitation cases. So whenever there is an AI involved, there may be some sort of directive or regulation involved in future, probably. And with these small steps, at least with the subsequent harmonization by the jurisprudence of the Court of Justice, at least some sort of legal sphere may be able to be constituted. Not quite happy about this solution either, but presumably it might be most the safe solution, at least from the perspective of legislators, from the EU legislators in particular. So that would be my choice.
Thank you for the, well, rather pessimistic, but still there is some hope there. And there is still some hope there, and there is light at the end of the tunnel. I think somebody from the chat kind of also joins your not so optimistic view about the IP law in terms that, well, maybe IP law is not going to be relevant for the AI in software, or for the software at all, because everything's going to be produced by AI, and, well, it's very difficult to prove the IP ownership. Hanne, I don't dare anymore to ask whether you have a pessimistic or an optimistic view. So
no, yeah, I think I have more like practical view now. Maybe this is because of my work as a legal counsel, but I believe we need to now see how does the AI Act itself work, and obviously it's coming into force in different steps. The schedule is quite long, and on top of the act itself, we will see and get quite many guidelines and another type of like lower legislation. So in total, it's huge package. The AI Act itself is long, and then all of these different guidelines. There is like for companies and people who actually want to follow the act and know the limits and understand what is allowed and not allowed, and when you are in the high risk area, there is lots of to read and lots of to interpret. So that's already something. And then, as I already was saying, it's not only about the AI Act, but it's all the another legislation that we already have in force. For example, the copyrights and the and GDPR, if I talk like now from the European perspective. And there are lots of uncertainties. How does the rights and obligations in relation to these norms should be applied in the AI context? So that's not probably regulating AI, but more like enforcing legislation that is already in force and understanding more how does it fit to the AI context. So yeah, these are the questions that in practice many are asking now.
There are a lot of uncertainties and a lot of things we just simply cannot know before we get there, right? And one of the questions of the chat, or there's actually one new question of the chat, is, well, how will AI impact work and employment? And well, I would add to that, should we do something about it? Will it also impact employment law? Will it impact the I don't know, the law that somebody like the bias in the AI when the hiring processes are happening, which I think is already being partly implemented, but still.
And what I found really interesting, and that wasn't on my bingo card for what was it, 2023, it totally took me by surprise, was the actors strike in the US and the focus on AI in that context, where especially sort of minor actors, the ones who don't have major billings but contribute as extras, were able to use collective action to force the big studios into a apparently workable compromise. And for me, that was fascinating because, I mean, for all countries of the world, they hadn't expected strong union movements and collective action actually resulting in something good. It would have been not the US. But for me, that was a prime example of what might come. We need strong unions, and they are not as strong as they should be. And that also affects academics, I would point out. Imagine you want to go on strike, as at least we in the UK have been doing on and off for the last 3 or 4 years. And then our employer says, haha, fine, but you have left enough YouTube videos of your lectures behind to make a voice clone of you. And we will simply have that one read out the latest papers. The students are not going to notice. So I think in the field of collective labor and collective action, there are some really interesting developments and opportunities, I would say. And I would say, rather than legislation and regulation, we need strong collective action in that space.
It's interesting if we'll get collective action among software developers, right? Because picking back to the question that was in the chat, my reading of it was, I must say, the opposite, which is, I thought it's at least, from my point of view, it's a positive prediction that the role of copyright in software will decrease, right? But I don't think it will happen. I think that the software development is now such a lucrative business that will get enough lobbying to get an exception for software saying, well, but if it's an investment and human guided effort somehow by AI, you still do get the copyright if you are the licensee or user or whatever. Though the question is if, people who right now have maybe the most comfortable labor conditions in our society right now, while they're being replaced by AI, because I just can't imagine these companies sharing the profit with them. This never happened before, right? Like, will they organize it? It's probably a thing to observe in the future.
I think that's something which is very realistic to be happy. I mean, eventually AI affects, very realistic to be happening. Eventually AI affects like a lot of professions, a lot of things we do, right? So, I mean, well, all of us work in the university, all 5 of us, well, Hanne also is a legal counsel, but as teachers, we use AI a lot, but I wouldn't say that I'm that thrilled about all the ChatGPT possibilities to write the paper that I even wouldn't know if the student has written in themselves or not themselves. So those are very basic problems that I think we're also facing in every department of our society. So at some point, people gonna strike, or so, whether it will be software developers, teachers, or students, or all together.
Yeah. Sorry,
go ahead.
Yeah, or so you mentioned that at least at some point so there will be some strikes with regards to AI exploitation within different fields. Or we just admit that we use or apply the AI-based software and we get used to it, so that our work and work conditions are going to change at least at some point, or we are going to be remunerated for different kinds of works, or we are going to be remunerated for data that we fed to the AI-based system so that the AI is trained. So there are some different solutions to that part as well.
Yeah, I think that's an important point. And again, it gets us to the sort of the long history, I would say. We use the word Luddite for people who are against innovation or against technology. But if you go back to the historical Luddites and to Ludd, they didn't attack all technologies. They didn't attack every business that was using automated machines for spinning and weaving. They really targeted only those who used it and abused their workers, who fired them or had unsafe working conditions and so on and so forth. They were very, very selective. And I think we need the same sort of selectivity, I would say, to say, okay, yeah, fine, of course, our working conditions are going to change, but that doesn't give you, employer, now free rein to impose whatever new exploitative regime you want to do. And then again, I would say programmers are, and that reflects also what Palka was saying, in the way that the ones I'm least concerned at the moment. All the invisible work that goes into AI, the data cleaning, the annotation, typically done in developing countries, very often done with terrible working conditions. I think going back to Olja's point, as universities, I think we are under an obligation not to use click workers for our research projects, and to make sure that fair wages are paid when we are developing AIs. I've seen this. I examined a PhD at the Technical University in Munich, and they were very proud in saying, we did not go to Amazon Turk, the Mechanical Turk. We wanted a service that could guarantee minimum wage for click workers and annotators. And I think that for us as a sector and for the research environment is extremely important. Most exploitative AI practices for the future of work are invisible. They are people we do not even see.
Yeah, that's also actually a perspective that touches the point I made about the input data and questions that concerns the input data and rights and obligations in relation to that. And that's something I hope we and think we should discuss much more than we have, because now we have been really focusing the output and the possible harms there. But the invisible work, for example, is invisible. Yeah.
That's actually a great point, because oh, sorry, Hanne, did I interrupt you?
No, we can just continue. Yeah.
Because sorry for that. Because actually not all AI related challenges or technology then should be regulated by the AI regulation, but also just the the simple human rights, labor laws. They're still pretty much applicable for regulating these challenges and the exploitation of the AI. And I think that's something perhaps lawyers who work in the field of technology tend to forget, or tend to get seduced by those new legislations and new acts and new guidelines. But there are also these like more basic laws than AI regulation that we also need to think of.
Yeah, and then also we were discussing earlier about the different more like expert works and what will happen. Will the AI take, for example, my job as a legal counsel, or as the software developer's job, or that sort of discussion we had going on there. I think it's interesting to see and think how people and how myself, how I vision the AI. Do I believe that it's something so good and useful, the AI systems, that they can replace the experts? Or is there some sort of disappointment like coming, and then I'm facing that no, at least in coming, I don't know, 10 years, 20 years, they are not replacing legal counsels, and they are not replacing university teachers and researchers and so on.
You're muted, Burkhard.
On Olja's point, and that applies generally, I think, for the top theme of our book and technology and the law. When I talk to students, give career advice, what sort of laws should you study to regulate technology? Number one on my list is a field of law I know absolutely nothing about, and that is competition law. And we see that, I think, specifically in Europe, but I think that is going to be a theme. The one tool that is really going to be used to shape technology landscape is competition law, followed by its close ally, tax law. Do we give the right taxation incentives to steer technological development in the right direction? Or do we cross-subsidize already massively rich companies for doing even more abusive practices? So competition and tax. I mean, I know Isaiah Berlin, I think, said to HLL, tax law results in the immediate death of the soul. But I still think that potentially these two fields of law will play a massive role in shaping technology, possibly more than things like the AI Act.
And in a weird way, they maybe already haven't they, right? Like the world we find ourselves in right now has to a large extent been shaped by the relatively lax antitrust enforcement in the US, and whether they manage to turn it out or not, we'll see. It is 5:01, and in this sense, we've run out of time. So the last thing to do is to thank you all very much for coming, to our speakers for finding the time and for your thoughts. Thanks to the audience for attendance and the questions, and stay tuned. There will be the next session of this in about 2 months. And always remember, there's a handbook, research handbook on law and technology, where we go deep into these questions, where you can read interventions by our amazing speakers. So thank you very much, and have a lovely afternoon.
Thank you.
Thank you.